KCTV, Germantown Community Television, your hometown news and information station.
Welcome back. I'm Vince Perryman, and you're watching Legalese. Joining us on our show is John Cameron. We're discussing the Shelby County Environmental Court. John, before the break, we basically went through what the court is and all of what it is you guys do, which, I mean, it's a very unique court and very diverse as far as the range of things that you guys hear. How did the court come about? Because I know it started in the early 80s, and sort of Judge Potter has brought it along.
Well, it's sort of an interesting story. Prior to the establishment of the environmental court, the types of cases that we hear were spread among the various city courts in the city, and that was before the establishment of the General Sessions courts. And the environmental court began as a division of city court, really as a docket of city court. But the housing inspectors at that time, cases were being heard among every other type of case. So you have, murders, you have rape, you have theft of property, and then you have a case where it's a rental unit that's being maintained at a substandard level. The clamor for a better way of handling these type of cases arose in the summer of, I believe, 1982. There were over 30 reported rat bites in the city of Memphis, and what it was found is basically these were occurring in very low-income properties that were being maintained at sort of a very low level. Tennessee state constitution is unique among the United States in having a $50 fine clause. A judge in the state of Tennessee cannot assess more than a $50 fine for any type of case without benefit of a jury. So these cases were being heard among the various courts, and even if the case could be heard in an expedient manner, which from what I understand they were not, it was just things being reset, put off. The maximum fine that could be assessed against a property owner would be $50 plus court costs. So now that comes out to about $150. At the time, it was probably substantially less. If you are getting, let's go low end, $400 a month from a tenant for a property that has a hole in the roof for a rat problem or something like that, and you know that there's not going to be any further consequences against you, that $50 fine could rather easily be pocketed, especially if you own several hundred or even thousands of properties, and as a cost of doing business. The goal of the environmental court initially was to get these cases all heard before one judge, so that if someone were engaging in a pattern of renting out substandard properties, they could be held accountable. Not only by at first by issuing multiple fines on the same property, because the $50 fine can be assessed for every day that a property is in violation of the code. That was not happening, probably because the cases were just, the same property might go before a different judge, so there was a lack of continuity. That was really the first thing that was done, was to hold people accountable by having them before one judge. Then the number of cases heard by the judge started to increase, so that in 1992 we were able to successfully have the environmental court established as a general sessions court, along with injunctive authority. So not only could the judge fine for multiple violations, not only could the judge issue bench warrants for people that didn't show up for court, the judge could now, and this was Judge Potter. This is Judge Potter who sort of issued this whole property and this whole process and shepherded the court to the way it is today. With that injunctive authority, the court could now end a case with a court order, basically, in effect, a permanent injunction saying you are no longer to rent out this unit as a substandard unit. And if these properties arise again, you could be held in contempt of court with the potential of up to 10 days in prison. So that is basically the bare bones of how the court came to be a general sessions court. Beyond our meeting in 201 Poplar, starting in the early 2000s, we began to hear community court dockets, which is basically just an extension of our court out into the community. Our first was in Frazier. Beyond that, we have a docket in Whitehaven, in Orange Mound, in Millington, in Hickory Hill, and hopefully soon we'll have a court in Cordova as well, where we can hear violations of the city code at sort of the community level. There are several advantages to that. Not only do defendants who are brought into court not have to go down to 201 Poplar and feel like criminals. These are not criminal violations; they're civil violations. Mm-hmm. You don't have to pay for parking. It sort of underscores that our whole goal is to get the property cleaned up, not to punish anyone. We will punish if we have to, but our main goal is just to end mm-hmm. whatever the violation, be it cars in the yard, high grass and weeds, dilapidated structures, whatever it is. That's our main goal, is just to get it cleaned up. But it also allows the community to come in and see what we're doing, be involved in it. Mm-hmm. In some cases, we have community members who are helping the police and code enforcement identify the properties that are in their communities and that are in needing of citation to court. So it's been a very successful thing, especially in our Hickory Hill court. We have averaged a good number more cases out there than we have mm-hmm. in other places, which is a good thing for everyone involved.
Well, yeah, and Hickory Hill is one of those areas that it's interesting because so much of it has, once it was taken into the city mm-hmm. or a portion, you've got so many rentals out there, mm-hmm. and then just some folks that just said, "Oh, I'm going to abandon my property."
Right. Not just rentals, but foreclosures. Mm-hmm. where you have a block with 5, 10, 15 houses that are with overgrown lots. What it does is it tells people who are maybe casing houses, mm-hmm. looking for crime to commit, says this is an open target. We try to close that target off. We really want to have people, especially the people who care enough to keep their property in shape, to reap the reward of that, of the care and that they put in their own property.
Okay. When we return from our break, we'll talk more with John Cameron about the Environmental Court of Shelby County. Please stay with us.